Good day, everyone. I am Michael Theodore, your course director in the Law of Remedies, and I want to welcome you to the Law School, the Holding Law School, as well as to the course Law of Remedies. This is just a brief introduction. I hope it will be brief to give you an idea as to what to expect in the course, what to expect from me, and how the year will shape up as we go along. Now, I just want to give you a little introduction to myself because who I am really shapes the expectations of the course, what my goals are in the course, and what you should be looking forward to. I graduated from the Faculty of Law at the University of the West Indies, and that will be many years ago, somewhere in 1981, and spent 2 years at law school, graduated from the law school in 1983, and I went to the Solicitor General's Department where I worked for several years. I left there and I then went to into private practice, a limited private practice, and also started a tour business. So I have some experience in business as well as the law. I always felt that one of the reasons for doing law for me was to be transformational, to try and change the society, try and improve it, and I thought that the law was a very good vehicle by which to do that. And so coming to teach at the law school is also a strategy in that program where I feel that it is one way of influencing future generations of lawyers. So when I look at the law, and I have to say at this point that when I had my interview for the post of tutor course director at the law school, I was at the time pretty okura with technology, and I went into the interview room with several options available. And so I was quite honest with the panel, and I told them what I thought about my contribution to the law school, and that is that legal education would need to be focused on how technology is going to transform practice. And at that time, I used to walk around with a knapsack with a laptop modem in those days that you had to plug into a telephone line. I had a portable printer and a portable scanner. And so I was virtually able to carry around an office with me anywhere I went. And I told the panel that legal education should move from where it was to a situation where lawyers will be able to be very mobile in how they transacted business, how they did practice their profession, and that legal education will have to follow suit. In fact, legal education should take the leading role in making that transformation. But that was in 1997, and I'm still working towards achieving that goal. And so you will see in this course in how it is delivered a very heavy bias towards technology. And for those of you who feel that you may not be technologically proficient or literate, I want to challenge you to see the need to be so. We are living in a technological age. The ways that we practiced in the past are no longer applicable. We are moving into an age where lawyers will have to redefine the way that they relate to their clients. And no client is going to be patient to come and wait in a lawyer's office for 4 or 5 hours waiting for a lawyer and at his convenience. After he comes back from court in the afternoon, after he has had lunch, after he has chatted with a couple of the colleagues to sit down and get business done. And so the technology, lawyers to keep clients will have to meet the needs of the clients where they are. There will have to be Skype meetings, there will have to be email communications, and a whole range of different strategies that lawyers will have to use to be able to survive in the future. So they will need to use the technology to collaborate with other lawyers. And so the course is going to be heavily weighted in terms of the technology. Another aspect of my life is that I am heavily involved in civil society. And that is important because the law relates to people. The law doesn't, the books and the principles that you are going to learn does not come first, it comes last. What comes first is how people relate to each other, the kinds of difficulties they get into, the kind of relationships they forge, and the kind of problems that ensue from those relationships. Whether it is in relation to one individual to another individual, a husband to a wife, an employer to an employee, or vice versa, the private individual to the state, the individual getting into some kind of legal arrangement with a corporation, one corporation with another. It all involves human activities. That is what the law is, how we as human beings impact our environment. And when we understand that, when we understand the subject of what we are studying, when we understand the subject of the law, then it is only then that we will be able to understand the law. And so getting involved in social activities, getting involved with your community, getting involved with people is a critical part of being able to make sense of the law, to apply it with relevance to the particular needs that it is supposed to serve. And so that is one of the reasons, that is one of the advantages that I have had in becoming involved in civil society. And you will see in the manual in my bio that I run a legal aid clinic in Toko, and that's just one aspect of my being able to understand my community. But I will talk a little more about myself and those influences in another video. I want to move on now to a little bit about the course. The course is called Law of Remedies. A little bit of history. When I did this program in 1981-83, the course was called Law of Compensation, Damages and Compensation. And effectively, it is the same course that now masquerades under the name of Law of Remedies. When I came to teach the course, I was a bit disillusioned when I saw, and my hopes were raised when I saw remedies, and I thought we were going into a much broader area of law, only to see that it was exactly the same as what I had been taught. But that course, the Law of Damages and Compensation, was relevant to the 1970s, when the primary law for resolving disputes and finding a remedy for a client's needs was through litigation. But since then, we've had a range of other remedies that have grown up either through the courts and more particularly through legislation. We have public law remedies, we have equitable remedies, we have statutory remedies where you have special legislation dealing with specific matters of the environment, equal opportunities, provisions, and a whole host of other areas that the statutes provide for, which run concurrently with your common law remedy of damages. And so this course is going to expose you to all of those areas, and they're going to ask you to, it is going to ask you, or I am going to ask you to expand your mind and focus on when a client comes to you with a particular factual situation, what are the range of remedies that are available to him to find a solution to his problem? Which is the most appropriate one in relation to his context, his pocket, his desires, and the efficiency that he needs to have his matter resolved expeditiously, so that technology will become, as I said, a critical part of the program. We're also going to look at what I call the modern lawyer, and that is that just as we have moved legal education, or to have moved away from the 70s, the 1970s, legal practice has also moved and is moving rapidly into a totally new dimension. When we look at the readings and the writings and the thoughts of legal practitioners in the developed world, they are seeing the law moving in a totally different direction. I think I may have a book here by Richard Susskind, Tomorrow's Lawyers. I would recommend that you buy it and read it. As you can see, it's a very small book, but it's a very powerful book. Richard Susskind was, and he still may be, the technology advisor to the Lord Chancellor in England. And over the last 10 to 15 years, he has written probably about 4 or 5 books on technology and how technology impacts the profession. And every time he writes a book and he makes a prediction about how technology is going to impact, and he says that, okay, well, in the next 5 years, this is what we see is happening. It happens in 3 years, and he has to write another book. So that his predictions have more than come to pass in many instances. And the previous book to this is called The End of Lawyers. How does it, and I can't remember the subtitle of the book, it's something like how do lawyers adapt themselves to the needs of a changing profession. I could be wrong, I'm most likely wrong on that. But in fact, what he is saying is that if lawyers do not adapt and change, and the profession does not adapt and change, then it will go the way of the dinosaur. So the modern lawyer, in the context of this course, is designed to help you to understand how you need to adapt, how legal practice needs to change, how you need to change and see the practice of law going into the future. Now, I know some of you may be challenged with the technology. And what I would say to you is this, that technology is a reality of our lives in this current time. The way that you practice will have to embrace technology if you are to survive. There's no ifs, ands, or buts about it. And so the best time to embrace it is at the law school when you have a chance to practice it, to use it, to make your mistakes with it. And also when you leave, you have an added value that you can work with and put on your CV to go to an employer to say, listen, these are the skills that I have. This is what I can bring to your firm. Okay? I want to talk about some special features of the course. Now, I want you to go to the blog, and the first topics that we have on the introduction covers a range of issues, which includes assessment, well, it includes the prerequisites for the course content, the objectives and student outcomes. It looks at the recommended text, your course management structure, teaching strategies, assessment strategies, and so on. I have spent a lot of time defining these issues for you so that you can understand them clearly. I spend most of my nights very often reviewing them and trying to make it as clear as possible so that you are well warned as to what I expect of you for the rest of this year. Now, I'm a married man, 28 years, and that time I can very well spend hugging up my wife instead of writing late hours of the night trying to make things clear to you. And so it is important that you spend time reading it because it will be very critical to you as to your survival in this course. We have a blog, so if you have any questions, you can post, or comments, you can post your comments. And the blog is a way that I will be communicating with you most of the time. It is the way that it allows me to have a discussion with you and you to have a discussion with each other. Okay? Another special feature of this course is the distance education program. It is a pilot, and you have a little handout about it, where we are going to have the teaching and the lessons virtually done online. So if you are interested, it is designed for those persons who may have challenges with their time and their personal lives and need to have some flexibility in terms of as to when they come to law school. It is also designed for persons who have some technology background or literacy, or even if you don't, you are interested in having it, and if we need to train you, we will train you to adapt to use the technology. I want, just wrapping up and coming to the close of this introduction, I want to talk a little bit about the manual. Now, I know that you have manuals, physical manuals for all your other courses. Now, if you look at how the course is structured online, all the material that is in the traditional manual for this course is online. But it is divided into small segments. It is divided not in one large conceptual framework, but it is broken up into small bite-sized chunks that you can look at, that you can assimilate, that is an exercise for you to do. And so it is designed deliberately in that way to help you to understand and process the information better. We are hoping to introduce links to the critical cases that are important for the course, so that when you are going through the online experience and you get to a case, you will see a link and it will take you directly to the case and to the material that we are asking you to read. Okay? We will produce a manual, but it will be done probably sometime later in October. And that is designed for those persons who need to feel something physical in their hands. But it is deliberately designed it is going to be produced late deliberately, so it allows you to engage in the actual use of the technology and get you familiar with it, so that the written manual will be a supplement to what we do. Okay, I don't want to burden you with too much now, but I think that if you go through the materials online, especially the introduction to the course, you will find as much information as you need to get going. I am always available to you, and that is part of my function as an attorney at law. You will find that you can get me on my my cell number. You have my personal email address. You have the course email address. There are many ways of contacting me. At least once a month, I will be having a web conference with every one of you, all 300 of you, at a particular time. And I will be sending out a survey to find out what is the best time that we can have that meeting. I would think it will be a time when you at home, in front of your computer, you relax, you reach home for the day, you had a shower, you hug up your family, and you can devote a little time to have a discussion with me about the course. This is especially designed for the students in the course, in the seminar groups that I do not teach. And it is to allow everyone to be able to speak to me as to what issues they are having, what difficulties they may be having. It's not just to say what is bad, what is good, what do you find helpful and useful. Okay, so what difficulties, what areas of the law you may be having a little trouble with that you feel that you want some clarification on from the course director. Now, if it is that you find different tutors saying different things, then I will take that into account. I will look at it and I will either arbitrate on it or have a discussion with them and come back to you as to what the definitive position is that we have all agreed to. Now, you would realize that we are all lawyers, and every lawyer is very self-opinionated as to what he thinks the law is and his particular view of the law. And that is the level of confidence that you need to have when you have to practice before the courts. It just means that we all have different perspectives and different interpretations, and everything is legitimate until it is determined by the court itself. The court is the final arbiter. Everyone has an opinion until the court decides on the issue. So that differences between tutors is sometimes real, and but it is the way that the law is structured and how we, part of the DNA that we have. So that if and when those issues arise, the video seminar conference is designed to raise it and to deal with it, and for the course to have a definitive approach on any of those issues, and we will deal with it in that way. Okay, so I want to thank you for coming to the law school. I look forward to meeting all of you.